Hi, I'm Dan Krause, and today I want to talk a little bit about trustee duties and what you need to do when you're a trustee. Specifically, I want to talk about a very important document that you will need called a certification of trust. Once again, my name's Dan Krause. I am an estate planning and elder law attorney, and I practice in Wisconsin, Illinois, and Minnesota. Now, these rules that I'm talking about apply in at least 36 states, although they're applied differently in each state. And when I say 36, I mean the states that have adopted the Uniform Trust Code. Now, I know New York will be a 37th if they pass it. It has been introduced. So a majority of the states go by the Uniform Trust Code. So if you are a trustee, if someone has passed away and they had a trust and you are the trustee and you need to take over and do the things that the trustee needs to do, or a person has passed on to you a trust that needs to be managed and you are the trustee, one of the things that you need to do, one of the very first things, is to create and sign a certification of trust. Now, under Wisconsin law and under the Uniform Trust Code, it is section 1013 of the Uniform Trust Code. In Wisconsin law, it is section 701.1013 of the Wisconsin statutes. And it says that you need 8 things on a certification of trust. So this is a document that, number 1, says that the trust exists and it tells the date that the trust was created. Number 2, it tells the identity of the person who created the trust. Number 3, it tells the name and address of the trustee. So if you're the trustee, that would be your name and address. The fourth thing, it talks about the powers of the trustee. What powers do the trustee have? Fifth thing, it says that it has to say whether the trust is revocable or irrevocable. Besides just saying whether it's revocable or irrevocable, if it is revocable, then it has to tell who has the power to revoke it. Sixth thing that we need is if there are co-trustees, it has to tell whether there are co-trustees, and it has to tell whether their powers are independent, whether each trustee can manage anything that they need to manage, or whether it's you have to have a unanimous consent so that all signatures are needed whenever a trustee deals with anything. The seventh thing that you need are the manner in which title to trust property is to be taken. And that's just basically the name of the trust. You have to say, this is the name of the trust, and this is how you should put it on the title to a vehicle or title to real estate, etc. And the last thing the certification of trust must have is that it has to say that the trust has not been revoked or modified or amended in any manner that would make the certification of trust inaccurate. If it's got all of those 8 things on it, then it is a proper certification of trust. The trustee can sign it. It should be notarized. And then you can take that to the bank, quite literally. You can take it to your investment advisor. You can take it to a signing or a title company for a closing, etc. And that is a perfectly legitimate and legal certification of trust. So if you have any questions about a certification of trust or anything trust related or estate planning related or elder law related, please let us know at Krause Estate Planning and Elder Law Center. We will be happy to take your call at 608-268-5751. Thanks for listening, and I hope to see you again soon.